Hello everyone, my name is Shashank and you guys are watching Aishaki. So guys, in today's video, we are going to discuss Article 20, Article 21 and Article 22. So let's get started. So guys, इससे पहले मैंने Article 14 से लेके Article 19 तक वीडियोस बना रखी हैं, आप जाके उन्हें देख सकते हैं. उन सभी का लिंक नीचे डिस्क्रिप्शन में मिल जाएगा. तो चलिए शुरू करते हैं Article 20 से. प्रोटेक्शन इन रिस्पेक्ट ऑफ कन्विक्शन फॉर ऑफेंसेज. सो इस आर्टिकल में हमें 3 प्रोटेक्शन प्रोवाइडेड हैं. First one is Ex-Post Facto legislation, second one is Double Jeopardy, and third one is prohibition against self-incrimination. Ex-Post Facto legislation. So this means enacting a law and giving it a retrospective effect, and this is only applicable for civil legislation, while criminal legislations cannot be given retrospective effect. Second was Double Jeopardy. This means that an individual can be punished for a crime only once and also not beyond the period prescribed by the authority. And the third was prohibition against self-incrimination. No person accused of an offence shall be compelled to be a witness against himself. Article 21. Protection of life and personal liberty. No person shall be deprived of his life and personal liberty except according to the procedure established by law. What is procedure established by law? So it is procedure laid down by the statute or procedure prescribed by the law of the state. Accordingly, first there must be a law justifying interference with the person's life and personal liberty. Secondly, it must be a valid law. And thirdly, the procedure laid down by the law should have been followed. Procedure prescribed by the law sustaining the deprivation of personal liberty shall act in violation of Article 21. The article stands not merely for the right to life and personal liberty, but also for the right to dignity and all other attributes of human personality that are essential for the full development of a person. Article 21 has become the foundation stone of Part 3 of the Constitution. Meaning of life and personal liberty. Life is not merely an animal existence or survival. It would include the right to live with human dignity and all those aspects of life which go to make a man's life meaningful, complete and worth living. The expression personal liberty covers a wide variety of rights which go to constitute the personal liberties of a man, other than those which are already included in Article 19. The courts are inclined to give the widest amplitude to the expression. On account of liberal interpretation, Article 21 has now come to be invoked almost as a residuary right, even to the extent which the founding father never dreamed of. Instances of protection under Article 21. Article 21A, Right to Education. By the Constitution Act 2002, 86th Amendment Act, a new fundamental right has been provided by inserting Article 21A. It casts a duty on the state to provide free and compulsory education to all children between age of 6 to 14 years. To implement this right, the state will enact appropriate laws. Education being a concurrent subject, laws may be enacted either by the Union or the states. By the same Amendment Act, Article 45, a directive principle relating free and compulsory education for children has been replaced. Now this Article 45 directs the state to provide childhood care and education to children below age of 6 years. The 86th Amendment Act has added one more fundamental duty to Article 51A. Each parent or guardian has a duty to provide educational opportunities to his child or ward between the age of 6 to 14 years. Now coming up to the Article 22, protection against arrest and detention in certain cases. The authority cannot arrest or detain a person without properly informing him or her of the grounds for such arrest or detention. The detained or arrested person must be produced before the nearest magistrate within 24 hours of arrest, excluding the holidays and the time taken during the journey. The period of detention cannot be extended beyond what is authorized by the magistrate. So, what are the protections are given against arrest? Article 21 guarantees right to life and personal liberty. A law may be enacted by a legislature depriving a person of his right. Article 22 sets out certain limitations upon the powers of legislature. If a law contravenes the conditions or limitations prescribed by Article 22, the law would be a nullity. Article 22 is not a complete code. It has to be construed with Article 21. Article 22 has two parts. The first part consists of clauses 1 and 2. These clauses apply to all arrest made under any law except under a law of preventive detention. The rights flowing from this article in case of ordinary arrest are: first, right to be informed of the ground of arrest, right to consult and be defended by a lawyer. Third, right to be produced before a magistrate within 24 hours of arrest, excluding the time of journey. Fourth, right to be detained for more than 24 hours without the authority of a magistrate. Protection of Article 22 is not available. The above rights are not available to: first, an enemy alien, and a person detained under a law of preventive detention. So, what is preventive detention? The second part of Article 22, comprising of clauses 4 and 5, provide safeguards to detainees under a law for preventive detention. It is noteworthy that these safeguards are available even to enemy alien. Preventive detention is the detention of a person where the evidence against him is not sufficient for conviction by a court but is sufficient to justify his detention for reasons of defense, foreign affairs, security of state, maintenance of public order, etc. Punitive detention punishes a person for something done by him. Preventive detention prevents a person from doing something. Preventive detention is a precaution taken by the executive. Its justification is reasonable suspicion or probability. Our constitution considers that preventive detention is a necessity, but it must be subject to limitations to prevent misuse. Examples of law providing from preventive detention are: first, Preventive Detention Act 1950, which is repealed. Second, Maintenance of Internal Security Act 1971. It is also repealed. Then third, Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. Fourth, National Security Act 1980. And fifth, Prevention of Terrorism Act 2002. All such laws conform to and contain the safeguards provided in Article 22. The safeguards are: if the detention is more than 3 months, the matter must be referred to an advisory board. The detention may be continued only where the advisory board considers that there are sufficient grounds for the detention. Grounds of detention must be communicated to the detainee. The detainee must be given an opportunity to make a representation against the order of detention. The 44th Amendment Act proposed to reduce the period of detention without reference to the advisory board from 3 months to 2 months, but this provision of 44th Amendment Act has not been brought into force. Let's see some case laws of Article 21. In Consumer Education and Research Center vs. Union of India, the Supreme Court held that the right to health and medical aid in order to protect the health and vigor of a worker while in service or after retirement is a fundamental right under Article 21. Please read it with Article 39E, 41, 43 and 44 and 48A. In Unicretion JP vs. State of Andhra Pradesh, the Supreme Court, while interpreting Article 21, held that right to education up till primary level is a fundamental right of every children till the age of 14 years. Thereafter, his right to education is subject to the limits of economic capacity and development of the state. Some case laws on Article 22. In Bhim Singh vs. State of Jammu and Kashmir, it was held that remand order obtained by the police from the magistrate without producing the arrested person before such magistrate within 24 hours is violative of Article 22, Clause 2. In State of Madhya Pradesh vs. Shobaram, the respondents were arrested on a complaint of criminal trespass. The arrest was made under provisions of Code of Criminal Procedure and the trial was held in the Nyaya Panchayat functioning under the Madhya Pradesh, which sentenced him. The court held that Section 63 of the aforesaid Act was ultra vires as it provided no lawyer that could plead a case before a Nyaya Panchayat. This was violative of Article 22, Clause 1 of the Constitution. Justice Hidayatullah pointed out that a person arrested and put on his defense against a criminal charge which may result in penalty is entitled to get right to defend himself with the aid of a counsel, and any law that take away his right offends against the Constitution. So guys, Article 20, 21 and 22 is completed. I hope you like this video. Please make sure to subscribe and press the bell icon. Also like and share this video. Till then, be happy, be focused.